Hello everyone, I'm Apurva Pandita and welcome to livelaw. In a significant ruling, the Supreme Court clarified that children born from marriages considered invalid or void or voidable under the Hindu law have the right to inherit a portion of their deceased parents' property. However, this inheritance is limited to what the children would have received in a theoretical division of the Hindu joint family property. Importantly, they do not have rights to properties belonging to other family members. This decision applies specifically to Hindu joint family properties governed by Hindu Mitakshara law. A bench led by CJI D.Y. Chandrachud was hearing this case, which arose from a reference challenging a previous judgment in Revana Siddhappa versus Mallikarjun 2011. This earlier judgment had stated that children born from void or voidable marriages have the right to inherit their parents' properties, whether those properties were self-acquired or ancestral. The heart of this matter was the interpretation of Section 16 of the Hindu Marriage Act 1955. This section grants legitimacy to children born from marriages considered invalid. However, Section 16 Clause 3 specifies that these children are entitled only to their parents' property and have no claim over other family members' shares. The central issue revolved around determining when a property could be considered as belonging to the parent in a Hindu undivided family governed by Hindu Mitakshara law. The court explained that according to Section 6 of the Hindu Succession Act, the interest of family members in a Hindu Mitakshara property is determined by imagining a partition of the property just before their death. Children born from invalid marriages have a right to the share that would have gone to their parents in this notional partition upon their parents' death. But before delving into the arguments raised before the bench, let us understand the background first. So the Section 16 of the Hindu Marriage Act 1955 addresses the status of children born from marriages that are considered null and void under Section 11. It states that if a child would have been considered legitimate if the marriage had been valid, then that child is deemed legitimate. However, there is an important exception in Section 16 Clause 3. This part clarifies that this legitimacy does not grant the child any rights to inherit property from individuals other than their parents. This is especially relevant in cases where if not for this law, the child would have been unable to inherit any property because they were not the legitimate child of their parents. If I say it in simpler terms, this section ensures that children born from marriages declared null and void are considered legitimate, but it does not give them the right to inherit property from anyone other than their own parents. In two previous court cases, Bharata Mata and another versus Vijay Renganathan and others, and Genia Kyotan versus Kumar Sitaram, the Supreme Court had held that children born from marriages declared void cannot inherit ancestral Coparcener property. They can only claim a share in their father's self-acquired property. However, in the case of Revana Siddhappa, a two-judge bench had different opinion. They believed that such children should have right to whatever property their parents acquire, whether it's self-acquired or ancestral. Because of this difference in opinion with the previous decisions, the matter was referred to a three-judge bench for further consideration. Coming over to the arguments now, the arguments in this present case revolved around two key legal sections. Section 16 Clause 3 of the Hindu Marriage Act and Section 6 of the Hindu Succession Act. Section 16 Clause 1 and 16 Clause 2 of the Hindu Marriage Act make children born from void or voidable marriages legitimate. But Section 16 Clause 3 says that these children do not have rights to inherit property from anyone except their parents. Section 6 of the Hindu Succession Act deals with how ancestral property is inherited. The main question was, when does the property become the parent's property for the child to inherit? There were two opposing views. Some argued that the Hindu Marriage Act intended to give legitimacy to children, and this should include the right to their parents' ancestral property as well. They believed that calling a child illegitimate was not fair, as it was the marriage that was problematic and not the child. So legitimacy under Section 16 of the Hindu Marriage Act should grant them rights in their parents' ancestral property as well. While others believed that Section 16's legitimacy did not automatically make a child a Coparcener in ancestral property. Coparcener rights depended on survivorship, not just being legitimate. They thought that only the parents' self-acquired property passed down by inheritance could be inherited by these children. They argued that this distinction was reasonable to protect the rights of other coparceners in the family. Well, in a sense, it was a debate between giving these children broader rights to ancestral property or maintaining a more limited interpretation to balance the interest of all family members. With this, we have come to the end of this video. We really hope that you like our content, and if you do, then do not forget to like and subscribe to our channel. Now you can also become a member by donating ₹89 per month. Thank you so much.